I welcome the opportunity to speak on this bill today, a bill which I believe will be one of the most important bills passed in this government's lifetime. I would also like to commend the government and indeed the Minister for bringing this bill forward and producing a bill, the wording of which is widely lauded by political society and by civil society alike. Children's rights in this referendum are lacking, and the Constitution as it stands is failing them. The obvious absence in Bunreacht na hÉireann of the provision of rights for children is stark. We have seen evidence of the impact of this absence before now, and we need to make this a thing of the past. It has been obvious that this major problem needs to be rectified, and the answer to a legal problem can only be a legal remedy. As such, a fundamental change to the way we treat children in our Constitution is necessary. Historically, parents' rights were seen as paramount, and despite evidence to the contrary, it was widely accepted that parents knew best. The family were afforded special protection by the state. This special protection can be seen in many different cases over the years. And while no one is denying that the family has a special interest and should have that place of paramount importance in the Constitution, it cannot be used to denigrate the right of children as a secondary issue. The Kilkenny incest case, the Ryan Commission report, the Baby Ann case and the Roscommon incest case are all glaring examples of the failings of not only our legal system, but the successive governments of this House who have shied away from implementing the legal changes necessary to protect our children. When we look back over these reports, the details of which can only be described as abhorrent, it is absolutely clear that the state failed to protect the victims in each. The Kilkenny incest case highlighted a legal stumbling block. It found that the very high emphasis on the rights of the family in the Constitution could give a higher value to the rights of the parents than to the rights of the children. This proposed amendment will mean that children in the future will be protected from harm and will place the child at the centre of decision-making, regardless of their parents' marital status. The Ryan report shocked the nation. That children were suffering systematic abuse in more than 200 state-funded institutions was a blatant indication of the lack of protection afforded to them. In that report, it was advised the needs of children needed to be foremost in all policies affecting children. Again, this amendment ensures that in any court proceedings, the interests of the child will be made paramount. Such a move should bring about a greater focus on these issues through our childcare policies. The Baby Ann case saw the Supreme Court rule in favour of a child's natural parents, even though Baby Ann had been given up for adoption by them 2 years previously. This was in recognition of the special protection given to parents in the Constitution. Yet there was no individual protection afforded to Anne, the child at the centre of the case. This amendment will provide that the rights and protections enjoyed by children are to be enjoyed by all children, irrespective of their parents' marital status. The Roscommon incest case, an abuse case, where the married parents of a large family sexually abused their children for more than a decade, was another stark example of the failing of the state and its legal architecture to protect children. In this case, the children's mother was able to secure a High Court order preventing a local health board taking the children into care. Consequently, the children stayed with their abusers for many more years than ought to have been. Constitutional guidance gave priority to the marital family. Again, this type of failure will be prevented by this constitutional amendment. I could go on. In all, there are 17 major reports on gross child protection failings, 17 tragedies of vulnerable children suffering abuse and neglect. To echo the Tánaiste yesterday, Eamon Gilmore, we are at last being informed by the bitter lessons of the past. We have learned from the dark history of our past when children's interests were ignored. What this constitutional amendment will do is provide the legal tools so that these gross failings cannot happen again. Our country will be constitutionally bound to treating future generations fairly, equally, and with their best interests at the very centre of decision-making. Article 42A is an important step in strengthening the protection of all children in the state. It is a most welcome development, identifying children as much more than property of parents or the state. They are included in our society as children in their own right, vulnerable individuals who enjoy security and protection as an inherent right. Thank you, Chair.
Thank you very much, Deputy Nolan. I now call on Deputy Michael Cole-Reevy. I understand you're sharing with Deputy Mark Ferris, is that correct?
That's correct. Thank you,
Chair.
Chair.
Agreed? Agreed.